Have you ever puzzled over the difference between mediation and arbitration? Well, you're not alone. These two methods of dispute resolution are often used interchangeably, but they're quite distinct in their approach and outcome. Mediation is a process where a neutral third party, known as a mediator, helps opposing parties to reach a mutually acceptable solution to their dispute. The mediator doesn't make decisions for the parties but rather facilitates communication, promotes understanding and focuses the parties on their common interests. The process is generally informal. It may involve one or more meetings between the disputing parties and the mediator. It's about negotiation and compromise. The mediator might propose a solution, but it's up to the parties involved to agree upon the final resolution. If an agreement is reached, it can be formalized in a written document, which can then be made into a legally binding contract. Now, let's pivot to arbitration. Arbitration is a process where a dispute is submitted by agreement of the parties to one or more arbitrators who make a binding decision on the dispute. In choosing arbitration, the parties opt for a private dispute resolution procedure instead of going to court. Typically, the arbitrator is a legal professional or an expert in the field related to the dispute. The process, while more formal than mediation, is still less formal than a court proceeding. The arbitrator reviews evidence, hears arguments, and then issues a decision which can be either binding or non-binding, depending on the terms agreed upon by the parties. So what are the key differences between mediation and arbitration? First, the role of the third party differs greatly. In mediation, the mediator facilitates negotiation and proposes solutions but does not impose a decision. On the other hand, an arbitrator hears evidence and makes a binding decision. Second, the outcome of mediation is entirely in the hands of the disputing parties. They can choose to agree or disagree with the proposed solution. In arbitration, however, the arbitrator's decision is final and the parties have to abide by it. Third, mediation is generally a more informal, flexible process, while arbitration follows a more formal, structured procedure. Fourth, the outcome of mediation can foster a positive relationship between the parties as the resolution is mutually agreed upon. Arbitration, due to its more adversarial nature, may not preserve the relationship in the same way. In a nutshell, mediation and arbitration are two different methods of dispute resolution, each with its own benefits and drawbacks. The choice between the two depends largely on the specifics of the dispute and the relationship between the parties involved. Pondering over these differences might help you decide which method is the best fit for your situation. So, next time you hear about mediation and arbitration, you'll know that they're not just legal jargon. They're practical, alternative dispute resolution methods, each with its own unique approach and outcome. Knowing the difference is not just useful for law students, but for anyone who might find themselves in a dispute.